Good afternoon and welcome to today's webinar on the review of key immigration case law of 2022 with Adam Pipe of No.8 Chambers. For those of you who haven't joined our webinars before, my name is Sammy. I'm the Business Development Assistant of DG Legal. The slides from today's presentation will be sent over tomorrow and a recording of the webinar will be made available. So if we do run over, you are welcome to leave and watch the rest at another time. So we are in webinar mode, so we can't see or hear any of you. So if you have any questions, please use the Q&A function so our speakers can answer your questions. So Adam Pipe is a barrister specialising in immigration, asylum and human rights law. He is ranked by Chambers and Partners for immigration law in the Midlands. Over to you, Adam.
Fantastic. Thanks, Sammy, and thanks for everyone who's joining today. It's a great opportunity to be here in the new year and review the key immigration law cases of last year. What I've tried to do is pack as much as I can in this webinar. So we're going to jump all around the houses and look at lots of different immigration law topics. Hopefully that'll be useful to you. And the slides contain a lot of material which you can use then when you're making representations in support of your applications, when you're advising clients on the best way forward, when you're drafting grounds of appeal or appeal skeleton arguments, or drafting onward grounds of appeal to the upper tribunal. So we'll go through lots of different issues and hopefully there may be a couple of minutes for questions at the end. And as Sammy said, pop those questions in the Q&A, not in the chat. What I was trying to do just as we were logging on is post some resources in the chat. I was unable to paste, but if the guys at DG Legal could paste the resources I've sent through in the chat, they'll also be available. There's a couple of unreported cases that I'm going to refer to and some PDF case law reviews and some other free resources. The other thing I wanted to say is, as we start, is that on the 28th of March of this year, I'm going to do another DG Legal webinar looking at visit visas. And it's going to be called Making Successful Applications and Challenging Refusals. And that's the link for that now is live on the DG Legal website. That'll also be sent round to participants after today. And you'll be able to log in because I'm sure you find decisions in visit visas super frustrating, and you get frustrated clients as well, especially when you tell them, oh well, we need to make another application, or well, we need to stick a PAP letter in. And even when the Home Office is consent, you just get another refusal a few months later, and you feel like you're stuck in Groundhog Day and you lack the right of appeal or administrative review. And JR is not really the greatest remedy because you don't get a decision effectively granting the visa. You just get a quashing of the decision and the Home Office reconsidering. So we're going to have a look at all things visit visas at 1 p.m. on the 28th of March. So that'll be fantastic. Let's crack on then. And the first thing I wanted to look at is the case of AAA, which is the challenge to the Rwanda scheme. I'm not going to spend a lot of time on this because this has garnered much headlines and is an ongoing challenge. But on the 19th of December, we had the decision of the Divisional Court made up of Lord Justice Lewis and Mr. Justice Swift, who found that the Rwanda scheme was lawful. So that in terms of the general challenge, they found that the Rwanda scheme was lawful. However, in respect of 8 of the claimants, they found that the decisions in their cases were flawed and the decisions were quashed. Now, permission has since been granted to appeal to the Court of Appeal and the Rwanda challenge goes on. I'm not going to say any more about that case. It's watch this space, but you've got the link and a summary in respect of that. I just want to deal with some procedural issues next in a case called AEB from the 18th of November. For those of you who are involved in taking cases to the upper tribunal, obviously the upper tribunal tend to deal with things in 2 stages. Firstly, whether there's an error of law in the decision. And if there's an error of law, then it comes to redecide the decision. And that decision can either be redecided in the upper tribunal or it can be remitted back to the first tier tribunal. Now, the presumption is that it will normally be kept within the upper tribunal unless the error of law has deprived a party of a fair hearing before the first-tier tribunal, or that the nature and the extent of the fact-finding that's necessary means that it's appropriate to send it back to the first-tier tribunal. So if there needs to be a de novo, a complete rehearing with evidence, often it's appropriate to send it back to the first-tier tribunal. And that's set out in practice, this practice statements of the IAC, paragraph 7.1 and 7.2. Now, in this case of AEB, it was a deport case, criminal sentence of 4 years. So you had to show very compelling circumstances. The appeal was dismissed. The upper tribunal found an error of law, including the fact that the first tier had not given the appellant a fair hearing. But what the upper tribunal did was hold on to the case and redecide it in the upper tribunal. And the Court of Appeal held that that was wrong, because the normal procedure that should be followed is to remit the case to the first-tier tribunal where there's been an error of law to deprive your client of a fair hearing. Now, there's good and the bad, because often clients don't understand when you've got a case in the upper tribunal, they just want it wrapped up there and then. And when you say, well, there's going to be another hearing and it might take a bit longer sending it back to the first-tier tribunal. Obviously, the downside of a case staying in the upper tribunal is if you fail in the upper tribunal, you're only left then with the Court of Appeal and having to show the second appeals test is met, which is a very hard test. Whereas if you get the case remitted back to the first-tier tribunal, you've got the sort of 2 bites of the cherry. So this case is useful where you're arguing, well, my client hasn't had a fair hearing and this case should be remitted back to the first-tier tribunal. What I've done is set out some key paragraphs from the judgment where you can use then in putting those in your skeleton arguments or in your Rule 24 response or in your grounds of appeal. And it says there that the normal procedure is to remit where there has been a lack of a fair hearing. And those are set out there in the paragraph. So hopefully that's helpful. Now let's change subjects to probably one of the biggest issues of 2022. And I'm sure it's one that's been a matter of concern to a lot of delegates today and a lot of clients that you've got. And that's the whole issue of extended family members, durable partners, Appendix EU and the withdrawal agreement. And the difficulty is with extended family members and durable partners, they had to apply under the EEA regulations before the 31st of December 2020. And we had 2 test cases last year from the president. The first one we're going to look at is Batul, and the second one is Celik or Chelik. Batul concerns extended family members outside of the United Kingdom. Now in Batul, what they'd done is they had not applied under the EEA regulations, but they'd applied under Appendix EU family permit. And I think that the application was in fact before the 31st of December, but the problem was they hadn't applied under the EEA regulations. Before the first-tier tribunal, it was conceded that they could not meet Appendix EU family permit. That concession was withdrawn at the upper tribunal. I think in the first tier, the argument was mainly surrounding Article 8. In the upper tribunal in Batul, the president found that they were not family members within the definition in Appendix EU family permit. The president also found that you couldn't treat the application under Appendix EU as an application under the EEA regulations. The argument was also advanced that the decision was not in accordance with the withdrawal agreement. Now, as you may know, when you're appealing against an EUSS decision, your appeal is brought under these regulations that are in the middle of your slide, the Immigration, Citizens' Rights Appeals, EU Exit Regulations 2020. And there are 2 available grounds of appeal: that the decision is not in accordance with the relevant immigration rules, that's Appendix EU or Appendix EU family permit, or that the decision is not in accordance with the withdrawal agreement. And the argument was made that this decision was not in accordance with the withdrawal agreement, but the president rejected that because he found that the withdrawal agreement didn't apply because they'd not applied for facilitation of entry and residence before 11 p.m. on the 31st of December 2020. The Upper Tribunal also considered whether Article 8 could apply, and Article 8 can be considered by the tribunal in an EUSS appeal. Now, unless there's been a statement of additional grounds, that would be, though, a new matter where under Regulation 9 of the 2020 regulations, you need the permission of the Secretary of State in order to get that permission for that to be considered by the tribunal. And as we're going to see, the Secretary of State has updated her policy and routinely now will not give permission for Article 8 to be considered as a new matter. I'll come back to that when we look at the next slide. There was also an argument that the EU Charter of Fundamental Rights applied. The Upper Tribunal said that had no bearing upon the appeals and it ceased to be part of the United Kingdom's law on the 31st of December 2020, although there's a recent decision by the Administrative Appeals Chamber, which takes a different view, and I've set out the link to, or the citation of that at the bottom of this slide. Now, in the resources I'm going to send out, and hopefully that may be posted in the chat as well, I'm going to send a link out to an unreported case that I did. For those of you who are on my mailing list or get my social media, you would have seen this case. I did a case before the First Tier and the Upper Tribunal where two, I think they were Ghanaian nationals, applied to join their aunt and uncle in the United Kingdom. The applications were made. One applied properly under the EEA regulations. There was a mistake in relation to the application of the other one. And even though it was the same form for the EEA regulations and the EU settlement scheme, the wrong drop-down was selected. And the representative accidentally selected the settlement scheme when they meant to select the EEA regulations. Although with the application, there was a statutory declaration asking for the case to be considered under the EEA regulations and indicating it was they both were applications under the EEA regulations. Both appeals were dismissed by the First Tier Tribunal. We appealed to the Upper Tribunal. The one that was correctly made under the EEA regulations, the argument was about the judge's assessment of dependency, and that was remitted back by the Upper Tribunal because he hadn't assessed dependency properly. In the other one, the Home Office accepted the judge had made an error, but said it wasn't material because in the light of Batul, we couldn't rely on the withdrawal agreement. And this was clearly an application under the settlement scheme and not under the EEA regulations. I argued before the Upper Tribunal that there was in fact also an application under the EEA regulations because it was clearly set out in the statutory declaration that there was an application under the EEA regulations. And I think it's regulation 29 of the EEA regulation sets out what is needed for a valid application. It just says you've used the correct page of .gov.uk. And they had used the correct page, they just chosen the wrong drop-down option. And the Upper Tribunal agreed that there was a valid EEA regulations application that had never been considered and therefore allowed the appeal under the withdrawal agreement. Have a look at that. It may help you. So that's an unreported case. Upper Tribunal Judge Blundell sitting with a deputy judge, and I've sent the link out and you'll get the link for that. Let's have a look at Celik or Celik. This is the situation of durable partners, and this is a common situation which I have a lot of sympathy for. They didn't apply under the EEA regulations prior to 31st December 2020. I think a lot of people perhaps didn't know and thought they just could apply under the settlement scheme. And a lot of them were trying to get married, but because of COVID, couldn't get married until after the 31st of December. So what happens then is after they've married early in 2021, they make EU settlement scheme applications. Those are rejected on the marriage basis because it's after the 31st of December 2020, and in relation to the durable partnership because they didn't have a relevant document. Again, the case came before the president in the Celik case, and he dismissed that appeal and again found that they had no substantive rights under the withdrawal agreement because their entry or residence wasn't being facilitated before 11 p.m. on the 31st of December 2020. So they couldn't invoke principles such as proportionality, which is set out within the withdrawal agreement, or the principle of fairness. I think it's very difficult because in a lot of other areas, there were all these COVID concessions, and you'd expect Appendix EU, because it was supposed to be flexible and generous, to have these concessions. Again, the president reiterates that Regulation 9 provides the human rights grounds can be considered, but it would be a new matter. And I've set out on this slide that the rights of appeal guidance has been amended. And it says in the rights of appeal guidance, it will not normally be appropriate for a new matter that raises protection or human rights grounds to be considered by the Secretary of State so that it can be heard as part of the citizens' rights appeal unless it's been made through the relevant application. And I did a Celik type appeal yesterday, and unsurprising, the Secretary of State had refused permission for Article 8 to be considered. Now, part of me thinks, and this is just my thoughts, that actually that's no bad thing, because often these cases are not prepared with an Article 8 mindset, and they don't really address Article 8. So often there's a rush for practitioners to try and get permission for Article 8 to be considered. But actually, if your Article 8 case is not set up very strongly, it's likely the appeal will be dismissed. And then any fresh Article 8 application you make may be subject to fresh claim provisions. So actually think about whether you do want Article 8 to be considered, or whether it's better to hold back and then you can make a separate Appendix FM application. And note the partner definition has been changed in Appendix FM. So European nationals with pre-settled status can apply for, or their partners can apply, and they can rely on being in a relationship with an EU national with pre-settled status. Although, because you might be applying as somebody without leave to remain, you'd have to show EX1A or EX1B were met, so children or insurmountable obstacles. So still quite a difficult case, but then you could also put all the sort of compelling circumstances forward under Gen 3.2 and Article 8. Again, another unreported case, and I've circulated this week. The appellant in the case was called Kabir. It's a decision of Upper Tribunal Judge Canavan, and you'll notice actually on Free Movement, there was an article posted on this yesterday, because the first-year tribunal judge had allowed the appeal on the basis that even though she didn't have a relevant document, paragraph B, Roman 2, double B, triple A, there's a mouthful, of Annex A, and the definition section of Appendix EU was met in this case because the person had leave under another provision when they applied. And the upper tribunal are scathing about Appendix EU being barely comprehensible even to experienced legal professionals, including the Secretary of State's own representatives. And they say this: in short, some part of the rules relating to the EU settlement scheme are so difficult to comprehend that it is at least arguable that they lack the clarity of law. And the upper tribunal say, we just don't understand the meaning of this paragraph triple A, but the Secretary of State hasn't persuaded us that the judge has made an error of law, so we find no error of law and the allowed appeal stands. I wouldn't be surprised if this case goes to the Court of Appeal because some clarity is needed. But in terms of the problems with the EU settlement scheme and the wording of the rules, and particularly with durable partners, this unreported determination is well worth looking at. In terms of Celik, I went on the case tracker website. So Justice, the government justice website has a case tracker facility. And if I logged on and had a look at Celik, I looked at on the 23rd of January, and it says on the 16th of January, Celik was referred to a Lord or Lady Justice for a decision on permission. So we're waiting a decision on permission to appeal in Celik. let me scroll through. So here's the head note of Batul. Here's some key paragraphs from Batul. And there's the section that deals with human rights as a new matter. And then here's the head note of Chelik. And again, some of the key paragraphs, including, again, the paragraphs in relation to a new matter. Obviously, disappointing decisions, which make it very difficult for clients, but do have a look at those two unreported cases that I've referred to today. A lot of us have had a load of EEA regulations appeals going through the courts because a load of clients applied as extended family members under the regulations just before the 31st of December 2020. The case of Singh in the Court of Appeal from July of this year is a classic example. So Singh, I think, was trying to join his uncle in the United Kingdom. This, in fact, was his fifth unsuccessful application for a residence card. The first-tier tribunal found that they not established dependency, and obviously dependency means meeting their essential needs. The upper tribunal found no error of law. The questions before the Court of Appeal concerned, firstly, whether dependency was assessed on a global approach. Do you have to show they need assistance with all of their needs, or can you just show it on a single approach? If they need assistance with one of their essential needs, is that enough? There was also a question about whether if you, the sponsor in the UK, pays for education, is education an essential need? It was actually agreed before the Court of Appeal that education was capable of being an essential need, but was not necessarily so. In each case, you've got to look. So in one case, education might be an essential need, in another case, not. In terms of the global or singular approach, they said, well, in fact, it ends up being the same because the former, the global approach, usually subsumes the latter. And what is needed is a sort of global assessment of the circumstances of the individual. And you don't just draw a bright line of what is essential needs and what is not. You look at each case on its own facts. And actually, if you're doing submissions or a skeleton argument on the question of dependency, Singh sets out some sort of key sections on that. So I'd encourage you to have a look at the Court of Appeal decision in Singh. As you know, with extended family members, we're often either considering dependency or household membership. And obviously that could change. You could be a household member in India, say, and then when you come to the UK, be dependent, or vice versa. But Shorab gave some guidance on household membership. Firstly, they said this, that there mustn't be a break in dependence or household membership from the country of origin to the UK other than a de minimis, so a very minor interruption. So there's got to be that continuity. Obviously, it can switch between the two. It could be dependence there, then membership of the household here, but there mustn't be a long interruption. In terms of what it means to be a member of a household, this is the definition that the upper tribunal gives. So this is what you want to address in your applications. That it requires a sufficient degree of physical and relational proximity to the EEA national through living in the household of which the EEA national is the head, living together as a unit with a common sense of belonging. There should be a genuine assumption of responsibility by the EEA national for the extended family member. Questions of the commencement of the assumption of responsibility and the duration of dependency or household membership are relevant. So that's what you want to be addressing. When was a responsibility assumed? How long has this carried on for? They also look at, in paragraphs 40 to 42, about when you can still be a member of the household, even when you're living away from the household. So perhaps you're in the UK, you've gone to university, but you're still part of your uncle's household, for example. Have a look at those paragraphs if you're having to address that scenario. Going back to durable partners, an issue came up before the tribunal as to durable partners who subsequently get married. This case also raises questions of fairness. So if you're ever challenging a decision because the tribunal haven't been fair in the hearing, have a look at this case as well. The case is Elias from the 28th of September. So the situation is, this was an application under the EEA regulations as a durable partner, refused and appealed. So the issue before the tribunal is whether the appellant at the relevant date was a durable partner. Subsequently, and I think it's post the end of the implementation period, so post 31st December, the couple married. Now, it was argued first that the marriage, the Home Office argued that the marriage was a new matter, so needed consent for that to be considered. The first tier tribunal disagreed, and actually the upper tribunal concurred with the first tier tribunal that a couple who get married, that's not a new matter that needs consent. And actually, if you go back to that old upper tribunal case of Mahmood from the Vice President, Mr. Ockleton, where he sets out what is a new matter and what is not. He gives that example. A couple who marry is not a new matter, where a couple who have a baby, the baby is a new matter. So what do they say? In any appeal against the refusal of the application, the post-implementation period marriage is not capable of amounting to a new matter for the purposes of an appeal under the 2016 regulations, and is at its highest simply further evidence as to the existence and durability of the claimed relationship. So basically that sheds light on the durability of the relationship. Now, in the first tier tribunal, the Home Office representative, the judge, having found it was not a new matter, wanted to cross-examine on the genuine and subsisting nature of the marriage. But the judge in the first tier tribunal wouldn't let that, because he said, well, in EU law, genuine subsisting is not the issue. The issue in EU law is whether a marriage is a marriage of convenience or not. If it's not a marriage of convenience, it doesn't matter. The upper tribunal held that the judge had been unfair in not allowing cross-examination on this issue. And you can see here, in order to conduct a fair hearing, cross-examination should be facilitated by the judge without undue interruption. So there's the fairness argument. What the upper tribunal did say, though, is the Home Office were entitled to cross-examine on the genuine and subsisting nature of the marriage, because the issue in this case, it wasn't a marriage refusal, it was a durable relationship refusal. So in cross-examining on the genuine and subsisting nature of the marriage, that shed light on the durability. And marriage of convenience, which the FTT judge had brought up, the jurisprudence concerning marriages of convenience doesn't apply in this case, because that wasn't the issue before the upper tribunal. I hesitated whether to include Akin Sanya in my slides today. It's a bit of a dead duck now, I'm afraid, but obviously in the High Court, the JR was successful, and Mr. Justice Mostyn held that Mrs. Zambrano, she was a Zambrano carer, she switched then to the parent route because she needed to access public funds. She then applied under Appendix EU because, of course, the advantage there was you could get settled status as with the derivative right, which you hadn't been able to under the EEA regulations. He found that the Zambrano right wasn't extinguished by leave to remain, and that Appendix EU referred back to the definition in Regulation 16 of what a Zambrano right was, and that only ruled out somebody with indefinite leave to remain, not somebody with limited leave to remain. So he allowed the JR. The Home Office appealed to the Court of Appeal, and ultimately the Home Office lost in the Court of Appeal, but they actually succeeded on the main issue. So they lost on the interpretation of the EEA regulations, because the EEA regulations only excluded somebody with indefinite leave to remain. And actually now they've since amended the definition, and it's all within Appendix EU and doesn't refer back to the regulations. But the Court of Appeal found that the Secretary of State's interpretation of what a Zambrano right to reside was correct, and that Mr. Justice Mostyn was incorrect. And it only arises in a circumstance where the carer has no domestic or other EU right to reside. There was that interesting observation of Lord Justice Underhill that Zambrano rights will always be waiting in the wings, and somebody will never be left unlawful. But if you've got a client now, I think they need to focus on the parent or partner route, whatever their route they're on, because if they've got this limited leave to remain, they're going to be refused. And I understand refusals are now coming through. In terms of the actual application of the Zambrano test, in Velage, the Court of Appeal and Lady Justice Andrews, who's also on the panel in Akinsanya, considered whether the test in a Zambrano case in Regulation 16.5c was a hypothetical test. Do you consider whether the appellant would be forced to leave on the assumption that the primary carer will leave the United Kingdom, or do you have only consider it where the impact on the British citizen would be, in fact, that they would be forced to leave? And the Court of Appeal decided that it only arises where the British citizen carer would be forced to leave, and you're not considered on a hypothetical basis. So sort of a toughening up of the approach in the Zambrano test, that it's not a hypothetical consideration, it only arises if they find that the British carer would actually be forced to leave. Let's give you a bit of a preview of what's to come in my visit visa webinar. So if you logged on late, I'm doing a webinar on the 28th of March for DG on challenging visit visa refusals and making successful visit visa refusal applications. A Scottish case called Gulam Sagra, a classic example. She was refused under V4.2A and C, so doubting that she was a genuine visitor or she intended to return. And the ECO questioned the credibility of the petitioner, obviously Scottish language because it's a Scottish case, the petitioner's circumstances in Pakistan. Now, in this case, the sponsor, who was a family member, had provided a statement or a statutory declaration which actually addressed the petitioner's circumstances in Pakistan. The entry clearance officer, when not accepting and doubting the circumstances of the petitioner, failed to deal with the statutory declaration and what was set out therein. And as a result, the Scottish Court of Session quashed the decision, or ordered a reduction in Scottish language. And so this emphasized the importance of the need for the entry clearance officer to consider all the material evidence when addressing a genuineness of a visit application and intention to return. So when you're preparing a visit visa application, don't just use a bog standard fill in the blanks statutory declaration for your sponsor. Have the sponsor address their own circumstances and any particular reasons for the visit, but also the circumstances of the applicant in their home country, and also get the applicant to do a proper declaration addressing their circumstances and setting out what the reasons are why they will return at the end of their visit. Because if the entry clearance officer fails to address it, that gives you a basis to challenge. So I've set out here some key paragraphs from the judgment, which again, you can use in your representations to your visit visa application. Here's a question for the representatives on the webinar today. Do you routinely do representations in visit visa cases? I think it's really necessary, especially laying the groundwork for a JR. Because if you've got those there, it creates that foundation for a good JR application. Or you can use these in your PAP letter or even your grounds. Another related case is the Diaquino case. That concerns a visit visa, but obviously this is an interview case. So the Brazilian national, non-visa national, and he was refused entry at port, and he was interviewed at port, and the questions were what he did in Brazil. And he was a barber, had a barber shop, and he set out how much he earned as a result of his work in his barber shop. They asked him in his interview at port, have you got any proof how much you earn? And he said, well, I can show you my bank account on my phone if you let me connect to the internet. But they didn't do that, just asked a couple more questions and terminated the interview and then refused entry. That was challenged, and one of the challenges was on fairness grounds. And it was accepted that he'd offered to provide the evidence of his income and that he was not given opportunity to access the internet or provide the evidence by another means. And the judge says this: however, in my judgment, fairness required the defendant to explore with the claimant what corroborative evidence may be available and ascertain what reasonable steps could be taken to secure access to it. The claimant was not given a fair opportunity to deal with this issue. Therefore, the defendant's reliance on the absence of documentary evidence of the claimant's income to refuse entry to the UK, whilst failing to permit reasonable access to such evidence, was tainted by procedural unfairness. Now, remember, arguments about fairness are context specific. And there's a bit of a sting in the tail in this case, because actually later on, he did produce the relevant bank documents and it showed that he didn't have the necessary funds. So the JR was ultimately unsuccessful. But in terms of a fairness point, I think that is very helpful. And particularly when you've got entry clearance interviews, that might be something that you can rely upon. And there's previous jurisprudence, I think it's the case of Mustafa from President McCluskey, that dealt with interviews and fairness in entry clearance. So it's either Mustafa or Mushtaq. Have a look on the upper tribunal from a few years ago about entry clearance interviews and fairness. Let's change the subject to health. And I'm conscious of the time, so we're going to sort of romp through these last subjects. So hold on to your hats. In AM Zimbabwe, in the Supreme Court, they endorsed the Paposhvili test in terms of the test in Article 3 in health cases. Obviously, since then, we've had the European Court of Human Rights decision in Savran and Denmark, and that concerns the sort of state's obligations in these type of questions. Let me quickly go to the head note. Forgive the small text, but that really sets out how you should address it and perhaps how you should address your submissions. So 1.1 first, has the person discharged the burden of establishing that he or she is a seriously ill person? So medical evidence, my client is a seriously ill person because they are HIV positive, they've got kidney failure, they've got end stage, whatever. Secondly, then, and this is the more complicated bit, has P adduced evidence capable of demonstrating that substantial grounds have been shown for believing that as a seriously ill person, he or she would face a real risk, one, on the account of the absence of appropriate treatment in the receiving country or the lack of access to such treatment. So we've got to show an absence of treatment or lack of access to such treatment. And would that lead to us being exposed to a serious, rapid and irreversible decline in his or her state of health, resulting in intense suffering or a significant reduction in life expectancy? So again, that probably needs some more medical evidence. And the tribunal make the point at point 3 that, well, question 1, medical evidence. And often the problem is in these health cases, we put the medical evidence in to show our clients are seriously unwell, but we haven't got the country type evidence that's needed to show this lack of access to treatment that would lead to intense suffering. And you may need medical experts based abroad, country experts, sort of charities or clinicians in that country who can provide the necessary evidence. Just staying on the subject of health, the tribunal are really cracking down, I think, on reports in relation to mental health, so psychologists and psychiatric reports. But anybody who instructs experts, please wake up at this point because this is important. In HA, there were psychiatric reports, and one of them was from Dr. Raj Persaud. If anybody of my age used to watch This Morning years and years ago with Richard and Judy, Dr. Raj was always on there, big TV personality. But unfortunately, he was suspended for a period of time for plagiarism. And he'd been writing some reports and had not properly disclosed everything in his CV and his reports. The president also found that his report bordered on becoming an advocate, not an independent expert. Now, if you're reviewing a draft expert report and you think your social worker or your psychologist or your doctor or even your country expert has become an advocate, you need to say, hold on, you need to revise this report because you're going to be, you've crossed the line into a role that's not your role. So don't be afraid to do that when reviewing draft reports. The other thing the upper tribunal emphasized was the importance of general practitioner, GP records, because it may be that somebody could sort of feign and exaggerate and fabricate before an expert. But actually, if you've got those GP records showing mental illness over a significant period of time, that adds weight. Now, some of our clients won't have been able to access GP, so that's difficult. But if you've got GP records, show them to your expert. Can I make a more general point? You know, if there's a previous determination or where there's a refusal, show it to your expert, please. Have the expert address it, because if not, it diminishes the value. You know, your client's paying a ton for that report, but then a judge says, well, hang about, I don't give that any weight because the expert didn't know that 2 years ago, another tribunal found the client to be a complete fabricator. So make sure they've got the relevant documents. But this emphasizes the importance of GP records. And also, I think if you've got consistent GP records, I would put them in your application bundle or in your appeal bundle. The upper tribunal also emphasise Article 8. Article 8 is not just an easy option that's a bit of an easier threshold than Article 3 in health cases. You can't simply succeed on Article 8 grounds because of a health issue. What you've got to show is that Article 8 is engaged, and you add the health factor as another cumulative factor within a cumulative Article 8 case, and then you could succeed on Article 8 grounds. Have a look at my last webinar, and the link should be in the resources I've pasted in terms of my private life webinar, where we address the rule, the very significant obstacles to integration rule that was in 276 ADE, now in Appendix Private Life, which might be helpful in arguing sort of health matters under Article 8. But here's the head note to HA. When you're instructing experts, and for goodness sake, I've said this before, don't get the clients to instruct experts directly. Please, as practitioners, draft a good instruction to experts. And what I would do is embody this head note from HA within your standard instructions to experts. Let's change the subject and touch on TOEIC. This is important actually for any case where there's allegations of fraud or dishonesty. In the past, the president, Mr. Justice McCluskey, as he then was president, in the Mudharange case, I've mispronounced that, we talked about this evidential boomerang about the burden of proof going back and forth. The president and vice president in DK and RK disagreed with that and said, in terms of dishonesty, there is one standard of proof, that's the balance of probabilities, and it's on the Secretary of State. And they drawn analogies between criminal cases with no case to answer. So have a look at that. Sometimes people in the past have talked about scales within the balance of probabilities and the higher end of the balance of probabilities, and there's one balance of probabilities test, but the burden's on the Secretary of State. But now, moving on from the SM and Kadir case, in terms of ETS allegations, the Secretary of State, their general evidence is enough to discharge the burden of proof upon them. So effectively, your client's going to have to give a proper response to that and can't just sit back and say, well, the Secretary of State hasn't proved the allegation. And that was upheld by the Court of Appeal in Akhtar and others. And I've given you the citation. Again, just changing subject for everybody. Let's move to deportation. So if you do deportation cases or if you do protection cases, wake up at this point, because this was a case where the first-tier tribunal had allowed a Jamaican case on the basis that SC was at real risk of Article 3 ill treatment in urban centres of Jamaica, but not in rural parts of Jamaica. But they found he couldn't relocate. That was overturned by the Court of Appeal, and they introduced this idea that because he was a criminal, there was a different approach to relocation, and you had to look at what was due to a criminal. In other words, a criminal can suffer a worse circumstance than somebody who's not a criminal. Unsurprisingly, the Supreme Court overturned that and found there is one approach to internal relocation, and it's this holistic, undue harsh assessment involving all of somebody's circumstances, including their psychological, health conditions, family and social conditions. So what I've set out is extracts from the judgment that set out what the House of Lords said in Januzzi and AH Sudan, which are Lord Bingham's judgment, and the sort of key approaches to internal relocation. So that's there. Just staying in the protection cases realm, For those of you who do Iraqi cases, you'll be aware of SMO and KSP, the country guidance. Huge head note in this case, so I've not set it out. Detailed guidance on issues such as relocation and the like in Iraq, and also the key issue of civil status identity documentation, which is often one of the thorny issues you have to deal with in Iraqi cases. Have a look at the CPINs. The Home Office have recently updated their Iraqi CPINs. And again, there is also a list going around with the Home Office keep tabs on which parts of Iraq and which offices are now issuing the old CSIDs and which are offering the new identity documentation. So that's the position with Iraq. OA Somalia is the country guidance on Somalia that updates MOJ, but it also looks at Article 3 living conditions cases. So whether more than just Somalia generally, if you're arguing return to a country would breach Article 3 because of the living conditions my client would end up in, this case is important guidance, and they apply the Paposhvili test, and they find that there needs to be this temporal connection. It needs to be the short amount of time between returning and the living conditions and intense suffering. So have a look at that. One of the other big issues in sort of protection cases, and it bleeds over into other cases as well, is Facebook evidence and social media evidence generally. And that was looked at in the XX case. XX was a prolific Facebook poster posting stuff against the Iranian regime. That was found to be done in bad faith, but he was found to be at risk and his appeal succeeded. This case gives guidance on the Iranians' monitoring of social media, the sort of risk that arises when somebody applies for an emergency travel document, whether the risk can be obviated by deleting your Facebook account, but also guidance on social media evidence generally. So let me just scroll through. So there's the key parts from OA and the living conditions case. Here's the head note from XX. So here's the bit on Iranian surveillance. Paragraph 4 looks at the pinch point of when they apply for ETDs in the UK. Then there's evidence of the monitoring in terms of Iran and Facebook. Then there's guidance on social media more generally, and the need not just to post a ton of Facebook pages, but to have this download your information section on all the relevant metadata. So have a look at that if you've got a case involving Facebook evidence. Let's switch to Appendix FM and applications as a partner, or applications generally under Appendix FM. And this requirement in Appendix FMSC that any income or savings, this is paragraph 1D of Appendix FM, must be lawfully derived. What does that mean? Well, in case of Fatima, she applied as a partner. She was joining her husband, Mr. Hussein, in the United Kingdom. He worked for Chicago Pizza. And on his pay slips, everything looked hunky-dory. You know, it looked like his employer was paying tax on his behalf and paying NI. He certainly wasn't the chairman of the Tory party. But it turned out that his employer was not, in fact, paying HMRC tax or national insurance. So what happened is the Secretary of State argued that this income should be discounted and was not lawfully derived. The upper tribunal disagreed, and they said, look, from Mr. Hussein's perspective, he'd done nothing wrong. He had no reason to suspect that fraud was being perpetrated by his employer. So we find this income in this case was lawfully derived. They didn't, but there's not a definition of what lawfully derived means, and they didn't give one. And they said, we don't attempt to define it. It has to be looked at on a case-by-case basis. And as you know, if you meet the rules, TZ Pakistan, the appeal should succeed. Obviously, as long as Article 8 is engaged, but this is a partner case, of course, Article 8 would be engaged. Now, if you don't meet the rules, you still have to consider Article 8 outside the rules. But remember, TZ Pakistan, important authority for saying if the rules are met, that's dispositive of the Article 8 case. Just a quick headline in terms of domestic violence, important case from Mrs. Justice Leven. This was a case for this phenomenon of transnational marriage abandonment. So where somebody's subject to domestic violence, they're tricked to go back abroad, so in this case back to Pakistan, and the lady's dumped there in Pakistan with her child. Often her passport or documents are taken away, so she's stranded, can't come back to the UK in order to access the domestic violence rule, where if she was a victim of DV in the UK and hadn't been abandoned abroad, could apply. And Mrs. Justice Leven found that that was a disproportionate interference with Article 8 in combination with Article 14 discrimination. So hopefully we'll see the DV ILR rules change to provide for this scenario. I'm conscious of time, so I just want to touch on the case of Butt. This is where the principles for indemnity costs in JR are set out. Poor Mr. Butt had to have 6 sets of JR proceedings in his Tier 1 entrepreneur application. And ultimately, the Secretary of State didn't comply with the consent order, which was much more actually than you'd normally expect in a consent order. So he'd won to a significant extent, and the failure to comply with that consent order led to the upper tribunal awarding indemnity costs. Indemnity costs are still going to be pretty exceptional, but if you've got a case, maybe in those visitor Groundhog Day, you may want to threaten indemnity costs. Have a look at the case of Butt. Also seen some significant changes in terms of victims of trafficking and leave to remain. And now in one of the most recent statement of changes, there's a new appendix to the immigration rules in terms of discretionary leave to remain for victims of trafficking. But the Court of Appeal considered EOG and KTT. In EOG, they overturned the decision of Mr. Justice Mostyn. That was to do with discretionary leave for somebody who was a reasonable grounds while they were waiting for the conclusive grounds, and there's that long delay. Mostyn had allowed the JR, but the Court of Appeal overturned. But the Court of Appeal did uphold the KTT judgment. That was where Lyndon J had found that where somebody had a conclusive grounds decision and they were waiting for their asylum claim, which also had the trafficking issue in it, there should be the provision for discretionary leave. There's also some helpful comments at the end of this judgment in relation to the delay in trafficking applications and delays in asylum, and I've used those in bail cases. In terms of nationality, we saw the challenge by the Project for the Registration of Children as British Citizens. That was unsuccessful in the Supreme Court, which held that the fee was a matter for the Secretary of State. But they had been successful in the Admin Court and the Court of Appeal on Section 55 grounds, and that has now led to the affordability fee waiver for registration of individuals as under 18. So helpful fee waiver. And what I've also said out, there's a great quote at paragraph 26 of the importance of British citizenship. Because of time, I won't read it out, but this is worth your weight in gold. So if you're doing a case where, say, you're arguing parents of a British child shouldn't go back and it's unreasonable, or maybe you're arguing undue harshness and you want to emphasize the sort of rights of the British citizen here, particularly a British child, this is worth setting out in your representations or your skeleton argument. So highlight this and cut and paste this, but for time, I'm just going to leave it there. Deportation, we've had the Supreme Court in HA, Iraq, upholding the Court of Appeal, so a good decision, that there's no notional comparator test when we look at undue harshness. The correct approach is in KO. They do unfortunately emphasize the test in MK Sierra Leone, which is quite a tough test on undue harshness, and I worry judges are going to approach this quite toughly. So do look at the Court of Appeal in HA Iraq, where Lord Justice Underhill says there's no reason why undue harshness might not occur quite commonly. Don't forget the very compelling circumstances test, paragraph 5, is a full proportionality assessment. And at paragraph 51, Lord Hamblin set out the relevant considerations that needed to be looked at in this full proportionality test. So again, highlight this, use that when you're making your representations in deportation cases and all the factors that need to be looked at. HA also looked at the issue of rehabilitation, and rehabilitation is a relevant factor. It may not be the key factor, but it is a relevant factor in the very compelling circumstances. A recent case about ongoing family proceedings is the case of CJ. This was in the case of deportation. And effectively, where there are ongoing family proceedings, it's likely that you're going to succeed on Article 8 terms. And in a deportation, you'd succeed under 117C6, that there were very compelling circumstances, but you're only likely to get leave while the family proceedings are pending. So have a look at CJ. We've got some deprivation of citizenship. That's a huge issue, particularly now. Much more of those appeals around the approach following Shamina Begum is a rationality review. Say for human rights, the upper tribunal assess human rights for themselves, but obviously we're looking at the effect of deprivation, not of removal, and they counsel against this sort of proleptic assessment. Two recent cases there, Berdika and Muslija. Have a look at those if you've got ongoing deprivation cases. It may be that something I can do a webinar on, the approach to deprivation cases post-Begum, so something we'll look at. Finally, as ever, ongoing saga of the long residence rules. Murpally looked at where there had been a previous defective notice. They were trying to say, well, that defective notice meant that his leave never expired and 3C carried on. Lord Justice Lewis disagreed with that and found that the defective notice did not mean that 3C leave continued, but those are very deep waters, and it's 2 minutes to 2. So I'm going to jump to questions. Let me just have a look at some questions, and I'll try and stop. Can someone not, there's a good question. Can someone not an EEA national with pre-settled status apply under FM? Well, yes, they can apply under Appendix FM if they've got a partner who's British settled, or if you've got an EEA national with pre-settled status, they can sponsor somebody. So they can sponsor somebody.
Shall I just cut in there quickly?
Yes.
I'd just like to say thank you to everybody for joining us. Unfortunately, I don't think we have enough time for all the questions. But thank you, Adam, for presenting. As a reminder, the slides and recording will be sent along tomorrow. And this afternoon, you should receive an email asking to rate us out of 5 stars. And we'll take any suggestions of feedback or any suggestions of future topics that you'd like to submit. So our series of webinars does continue on the 31st of January, where we'll be presenting a webinar on immigration law, human rights and adult dependent relatives with Jane Elliott Kelly and Eric Fripp of 36 Group. So thank you for watching and have a good afternoon, everybody. And if you have any time to stay for other questions.
Yeah, I think what people can do is they can contact me if they've got questions. My details there. I've had a look at some of them, some of the questions that are there. Just a question that is there about upper tribunal granting permission, but the respondent does not follow directions. What would be the next step? I suppose you can contact the upper tribunal and say the Home Office have breached directions. If it's not a fair hearing, can it be remitted back to the FTT? That goes back to the start of the webinar, where the normal thing is that something would be kept in the upper tribunal unless it's not a fair hearing, or there needs to be a complete re-fact finding. Usually it would stay in the upper tribunal. I think that answers quite a few of the questions. The rest are quite long questions, so people know where I am and can contact me. Can I just say thank you, and make sure you've checked out those links for the other resources that have been pasted in the chat. But thanks very much, everybody.
Brilliant. I'm sorry we've run over a little bit, everybody, so I know this is your lunch break, so you're welcome to get off.
Thanks very much, everyone. See you soon.
Thank you.